Brandon Rush on Facebook. My girlfriend came here on a K-1 fiancé visa and is going to divorce her ex-husband. Will I be able to get remarried to her if her ex-husband fails to get her green card within 90 days? I'm willing to do what I can to keep her in the U.S.
Well, tell me again what happened. I apologize.
So Brandon Rush says, my girlfriend came here on a K-1 fiancé visa and is going to divorce her ex-husband. Seems like she came here on the first marriage.
Right.
And will I be able to remarry her?
The answer is yes, but the only way that she can get her green card in the United States is through the first marriage. Now, when you come on a fiancé visa, you don't have to remain. This is what you need. Two things. I just had this conversation with somebody today. Two things you need when you come on a K-1 visa to establish that you can get a green card. You have to get married within 90 days, and your spouse has to have signed a Form I-864, which is the affidavit of support. So generally what happens is if you get married within the 90 days and your spouse files the adjustment and you came on the K-1 visa and then things break up, you can either refile a new adjustment or complete that adjustment under something called matter of Sesay. It's called the matter of Sesay adjustment. And what a matter of Sesay adjustment says is as long as you came on a K-1, as long as you got married in that 90 days and your spouse filed the I-864 affidavit of support, that's all that is required to establish that you're entitled to a green card. So in this particular case, Brandon Rush's girlfriend, if she got married, because I heard she got divorced, so she got married obviously within the 90 days, if the husband filed the adjustment, she should be completing that case or filing a new case based on matter of Sesay. If the husband, because in order to file the adjustment, the husband would have had to have filed the I-864 affidavit of support. If on the other hand, they never filed the adjustment of status, yes, Brandon Rush, was that his name? Brendan Rush? Whatever.
Brandon Rush.
Okay.
Brandon Rush.
Okay. So yes, Brendan Rush, you can remarry her, but then you would be filing an I-130 visa petition, a provisional waiver. She would have to go home and come back.
Milky Getacho on Facebook. I entered the U.S. with a B2 visa to visit my mother, the country, and my boyfriend. Amid my stay, COVID was declared as a global pandemic, and as I was pregnant with underlying health condition, I stayed more than my original plan. During my stay, I had an emergency C-section and gave birth. In that situation, it becomes extremely difficult to return. I filed the I-539 explaining my situation. Yet it's almost more than 6 months and I haven't heard anything from USCIS. I don't exactly know what to do. I'm a PhD student and a teacher back in my country. What's the likelihood of getting a new visa if I return to my country before the decision is made, before the decision is made and before the 180 days are counted? And can I apply in the consulate?
All right, so you need to do, the answer is you should leave or file for an extension in some other category. Just because you haven't heard anything doesn't mean you can stay here indefinitely until immigration makes a decision. Yes, you could leave. If you leave and they make a decision extending your stay for 6 months, then you would have stayed legally during this entire time. Your visa presumably would still be valid. And you wouldn't need to go back to the U.S. Embassy to get a new visa because you have a valid visa. If, on the other hand, you leave and they deny you, then yes, you would have to go get a new visa. And it would be very difficult because then you're an overstay and you gave birth in America. So, there's a big risk in leaving. There's even a bigger risk in staying because if you stay beyond the 6 months, you haven't done anything, then now all of a sudden you're out of status, even if they extend your stay. So let's say you filed the extension on January 1st, that gives you to June 30th. And it's June 15th and you haven't heard anything yet. And you say, you know what, I'm going to stay here until I hear. And then come August 1st, they give you the decision. And the decision is, we've agreed to extend your stay from January 1st to June 30th. Well, great. For the whole month of July, you're out of status. You're now illegal. So that doesn't help you either. So it's either going to be, you're going to file another extension, even though you haven't heard from the first one yet, or you're going to leave.
Thanks for watching. For more Bradshaw Live, like and subscribe to our YouTube channel.